Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we talk here at Washington Gun Law all the time about that the way we're really going to change the Second Amendment debate in this country is not through legislation, not through litigation, not through any of that. It's going to be through education. And those of you who've seen me speak publicly at one of my classes or one of my public speaking events know that I talk frequently about how all of us in the Second Amendment community, all of us lawful and responsible gun owners, have a moral obligation really to protect our community and to go out and to educate. And so what I really want to do now is I want to follow through on that mission, and I want to drop videos with you every now and then to give you some talking points, some things to talk about, so that if you're having a debate or if you're just having a discussion with one of your friends who might not be as entrenched into their Second Amendment rights as they should be, you can help explain the importance of these rights, or you can help explain the insanity of some gun control legislation that you may have kicking around in your state. So today we're going to take one of the most common arguments. We're going to talk about it. We're going to kind of dissect it a little bit and give you some talking points. So today, let's spend a few minutes and talk about the Second Amendment only protects muskets? Really? Okay, so the issue we're talking about is a common argument that's made. It's been made by people such as Gavin Newsom, Rob Bonta, Governor Inslee, Bob Ferguson, Joe Biden, and the list goes on and on and on. And the argument goes, when they wrote the Second Amendment, the only type of firearm they had was muskets. They never envisioned any of the weapons of war that we have on our streets right now. Now, the problem for that is twofold, okay? Number one, the case law doesn't line up with that line of thought at all. And the second thing is that I'm going to give you a bunch of very common sense questions to ask people who believe that, and they too will begin to realize the absurdity of that argument. Okay, now for the deeper, geekier stuff here, okay? The case that we talk about whenever we're talking about banning types of modern firearms is not the Bruin opinion. No, it's the Heller opinion. You see, because a number of years ago, Justice Scalia developed what was called the common use test, okay? Now, in a nutshell, the case law basically said, the question is always whether the arms in question are commonly possessed by law-abiding citizens for lawful purposes today. If the answer is yes, a categorical ban of such weapons therefore violates the Second Amendment. Now, to put in more simple terms, when we go back and we try to find a historical analog, that is something that justifies going back to the late 1700s, the only types of firearms that we have traditionally allowed to be restricted are firearms which are considered both dangerous and unusual. Now, the problem is that there is no modern firearm in common circulation today that could ever be deemed unusual and therefore can never be subjected to a blanket ban. That is the case law 101, but we really want to take things down to its most simplest form. And the most simplest form is to take the analogy that a person proffers, which is the Second Amendment only protects muskets because that's the only type of firearms in existence at the time they ratified the Second Amendment. Okay. Let's use that exact same logic and apply it to other constitutional rights. And these are the questions that I want you to ask these individuals. Okay, let's start with the First Amendment. Okay, there are many things that the First Amendment protects, but let's start first with the freedom of religion. Now, at the time that the First Amendment was ratified, there were very few organized and recognized religions in the United States. Everyone was either Anglican, Presbyterian, Congregationalist, a Quaker, a Lutheran. Some were Dutch Reformists, and then, of course, there was the Roman Catholics. So you're talking about 7 main religions here, okay? Does the First Amendment only protect the freedom of religion as long as you're associated with one of those 7 churches? What about the hundreds and hundreds of other religions that have sprung up? How about the thousands and thousands of community churches that are non-denominational? Does the First Amendment not protect any of them because they didn't exist at the time that the First Amendment was ratified? The First Amendment also protects free speech. Now, does that mean that the only speech that it protects is spoken word and anything we wrote with a feather pen and a quill? Because those are the only 2 types of speech that we had in existence at the time that the First Amendment was ratified. Or does it protect telecommunications? Does it protect digital communications? Does it protect all forms of modern communications? Well, we know the answer to that. Oh, so when the First Amendment was ratified, it also said that there was the freedom of a press. But does that only protect those that have old 1700 printing presses still printing on hemp paper? Or does that go to all forms of modern journalism, including electronic journalism? I think we all know the answer to that too. The First Amendment protects our right to privacy. Now, in the late 1700s, about the only way you could have your privacy invaded is someone would either have to peer through a window or kick in your door. Nowadays, as we know, there are thousands of ways in which a person's privacy can be invaded digitally, through other forms of technology, through data mining and things such as that. Does the First Amendment not protect any of that? Let's move on to the Fourth Amendment. You see, the Fourth Amendment protects us from unreasonable searches and seizures. But the only type of real search and seizure that could have occurred in the late 1700s would be government agents just kicking your door in and rummaging through your place. Does the Fourth Amendment only protect that, or does it protect all forms of searches and seizures? Does it protect us against electronic surveillance, digital surveillance, thermal imaging surveillance? We know the answers to these questions. When they wrote the double jeopardy clause in the Fifth Amendment, there was no such thing as DNA evidence. Are we suggesting now that a person who is acquitted at trial, but later on DNA evidence proves for fact that they committed the crime, that they could suddenly be retried because when we ratified the Fifth Amendment, we didn't have DNA evidence, so therefore double jeopardy wouldn't apply to that? I think we know the answer to that question. Oh, how about the Eighth Amendment, the protection against cruel and unusual punishment? Now, if you go back and you look, by the time we were ratifying our Constitution, we had kind of done away with burning people at the stake. That was kind of passé at that point. And so really the only two forms of cruel and unusual punishment that might be inflicted upon a person would, of course, be the firing squad or hanging. Nowadays, we have many, many ways in which we can inflict cruel and unusual punishment, but does the Eighth Amendment only protect the types of punishments which were both cruel and unusual back in the late 1700s, or does it protect us from all modern forms of punishment? And that is the fallacy that the Second Amendment only protects muskets. Because if that were the case, if our constitutional protections, if our inalienable rights are defined as they were in the late 1700s, well, then they're not rights anyways, are they? So hopefully that gives you a few talking points, a few arguing points, so that if you ever end up in a debate, an argument, or preferably what we'd like you to see is having a meaningful conversation and open dialogue with someone you disagree about so that you can share ideas and learn from each other. But whatever the situation is, I hope these talking points help you. Listen, we'll be doing more videos of this nature because, like I said, I think the only way that we're ever going to start changing the dynamics of this debate is through education. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. You guys should know how to contact Washington Gun Law by now, but if you don't, hey, all of that is in the description box down below. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.